everyone, I am Patricia BILLONES, and today I will be talking about Articles 1231 to 1237 of Chapter 4, Extinguishment of Obligations. So first is we have the Article 1231. It says here that obligations are extinguished by payment or performance, which is dito nakapaloob yung mga i-discuss ko ngayon, yung Articles 1232 to 1237. Next is by the loss of the thing due, by the condonation or remission of the debt, by the confusion or merger of the rights of the creditor and the debtor, by compensation, and by novation. Other causes of extinguishment of obligations, such as annulment, rescission, fulfillment of a resolutory condition, and prescription, are governed elsewhere in this code. In addition to those enumerated in Article 1231, other causes are death of a party in case of an obligation requiring personal service, mutual distance or withdrawal, where after the approval of his loan, the borrower, instead of insisting for its release, asked that the mortgage given by him as a security cancelled, and the creditor acceded thereto. The action that taken by both parties was in the nature of mutual distance, which is a mode of extinguishing obligations. Next is arrival of resolutory period, compromise, impossibility of fulfillment, and the last one is happening of a fortuitous event. So moving ahead to section 1, payment or performance, we have the Article 1232. Payment means not only the delivery of money but also the performance in any other manner of an obligation. So there are two meanings of payment according to the Lyon's book. First is, in ordinary parlance, payment refers only to the delivery of money. Second, as a legal mode of extinguishing of an obligation, it has a wider meaning. Payment may consist of not only in the delivery of money, but also the giving of a thing, the doing of an act or not doing of an act. So in law, payment and performance are synonymous. And now, let's move on with Article 1233. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. So when do we know if payment has been made? Here are the following principles. Payment has two requisites, identity and integrity. In identity, it must be the object or prestation itself which has been delivered by the debtor to the creditor. If the object is a specific thing, the debtor cannot compel the creditor to receive a different object, even if such different object is of the same or higher quality. If the thing is indeterminate or generic, then the creditor cannot ask for a thing of superior quality, and the debtor cannot compel the creditor to receive a thing of inferior quality. As an example, John obliged himself to deliver to Louise a specific horse. Read that John cannot require Louise to accept another horse, although it commands a higher price. Neither can Louise require John to deliver another horse belonging to John, although it can be sold only at a much lower price. So next is we have the other aspect, which is integrity. When we say integrity, payment must be complete in order to be valid. In other words, a creditor cannot be compelled to accept partial payments. So for example, Mike agreed to paint the house of Jasper for 100,000 pesos. Mike did not paint the kitchen anymore and instead asked Jasper to pay him 100,000 pesos less the cost of painting the kitchen. So since this is an example of integrity of prestation, Jasper can refuse to pay Mike because the debt of Jasper, which is to deliver money, will arise only after the debt of Mike is completely rendered. So next is Article 1234. If the obligation has been substantially performed in good faith, the obligor may recover, as though there had been a strict and complete fulfillment, less damages suffered by the obligee. This article is the first exception to the rule if there has been substantial performance. But the substantial performance by the debtor must have been done first in good faith and should only involve a slight deviation, meaning the difference is only negligible or so very small. It does not affect the main obligation and there has been no intentional departure by the debtor from the intent or cause of the obligation. So for example, A obliged himself to deliver 500 bags of cement to Robert for a certain price. However, despite diligent efforts on his part, Ace was able to deliver only 400 bags because of cement shortage. Take note that Ace wants to comply with his obligation to deliver the entire 500 bags, but he could not do so for reason beyond his control. So, under Article 1234, Ace can recover as though there had been complete delivery less the price of the 100 bags. Pero kailangan mapatunayan ni Ace that he attempted in good faith para mag-comply with his obligation. So, moving ahead with the next article, we have the Article 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. So this provision is the other exception to Article 1233. Kung ang payment is incomplete or irregular, pwede itong i-reject properly ng creditor. Pangalawa, in case of acceptance, the law considers that he waives his right. So therefore, the whole obligation is extinguished. So for example, Jessica agreed to paint the house of Nicole. According to their stipulation, Jessica would use a particular brand of paint. So if Nicole accepted the performance of Jessica, knowing that the paint used was another brand and without expressing any protest or objection, the obligation is deemed fully complied with. Hindi katulad sa Article 1234 na merong substantial performance. Jessica is not liable for damages that may be suffered by Nicole because of the reason that the performance is considered complete or regular. So now we're on the Article 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. So payment must be made by a third person who is obligated under the obligation. And who is this? Payment must be made by the debtor. In other words, the creditor is not bound to accept by a third person who has no interest in the obligation. Now, this general rule is subject to an exception if there is an express stipulation to the contrary. In other words, if the parties have agreed that payment can be made by a third person, then it will be valid. So what are the rules in case creditor accepts payment from a third person? First, if payment made by a third person was with the knowledge of the debtor, then the third person can compel the creditor to subrogate him in the creditor's rights, and the third person can ask reimbursement from the debtor. And without the knowledge of the debtor, then the third person can only recover in recovery reimbursement, only insofar as it has rebounded to the benefit of the debtor. He cannot ask for more, kung saan lang nag-benefit si debtor. But, the more important implication is the third person cannot compel the creditor to subrogate him in his rights. Di na makukuha ni third person yung rights ni creditor over the mortgage, over the guarantee, or any other rights. For example, Eunice owes Ellie the sum of 1,000. If Andy, a stranger to the obligation offers to pay Ellie, the latter may or may not accept the offered payment. Suppose Ellie accepts, the right of Andy to recover from Eunice depends upon whether the payment is with or without the knowledge or consent of Eunice. So without the knowledge or against the will of Eunice, if the actual indebtedness is 1,000 and Andy paid 1,000, he can ask reimbursement for 1,000 pesos. But if 400 had already been paid by Eunice, then Andy is entitled to be reimbursed only for the amount of 600, because it is only to that amount that Eunice has been benefited. So Andy can recover 400 pesos from Ellie, who should not have accepted it. And if Ellie acted in bad faith, he is liable also for interest in lieu of damages. In either case, if the payment of 1,000 pesos was made with the knowledge or consent of Eunice, Andy can recover from Eunice 1,000 pesos with all the rights of subrogation to the accessory obligations, such as mortgage, guarantee, or penalty. So, yung last article na i-discuss ko is yung Article 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. Since the provision of Article 1237 is for the benefit of the debtor, the subrogation can only take place with his consent. The third person who without necessity paid under such condition is amply protected by his right to reimbursement. So legal subrogation by operation of law is presumed in certain cases. So what is subrogation and reimbursement? Subrogation simply means that the third person can ask the creditor or compel the creditor to transfer whatever rights the creditor has over the obligation, such as if the creditor has a mortgage or a guarantee na constituted in his favor. Then the third person, by virtue of payment with the knowledge of the debtor, can compel that creditor to subrogate him or to transfer those rights to him. In reimbursement, the third person entitled by reason of payment has merely the bare right to be refunded to the extent provided in the second paragraph of Article 1236, without the right to the guarantees and securities of the original obligation. So for example, Elaine borrowed from Mark 10,000 pesos, and Julia is the guarantor. Without the knowledge or consent of Elaine, Rhea paid the 10,000 pesos. In this case, Rhea can claim reimbursement from Elaine for the whole amount of 10,000 pesos, inasmuch as Elaine was benefited up to that amount. If Elaine cannot pay Rhea, the latter cannot proceed against Julia, even if Mark is willing, because having paid without the consent of Elaine, Rhea is not entitled to subrogation. But if the payment was with the express or tacit approval of Elaine, Rhea would be entitled not merely to fulfill reimbursement but also to subrogation. Suppose the obligation of Elaine is secured by a mortgage of a land owned by Julia. Payment by Rhea without the knowledge or against the will of Julia cannot give Rhea the right to subrogation. Rhea can recover only insofar as the payment has been beneficial to Elaine. So I'll end it here. Thank you for your time and I hope you learned something. Bye-bye!